Now into the testimony phase of the CMPD Officer Randall Kerrick voluntary manslaughter trial. Already there is questions or statements of possibly a mistrial.
So Kerrick's charged with voluntary manslaughter for shooting and killing Jonathan Farrell in 2013. Farrell was unarmed at the time of the shooting. Evidence presented by the state on Tuesday. Defense claiming pictures it showed of Farrell's dead body could lead to a mistrial because they evoke emotion. They did from Farrell's family in the courtroom. Defense saying the jury could be swayed by simply seeing the family's emotion.
To the detriment of Kerrick and to prejudice this jury against him just by evoking that sympathy, Your Honor.
Judge took some of those photos out of rotation, the defense sticking to its guns, saying the pictures still evoke sympathy. Testimony continues today. Fox 46 in the courtroom, keeping you updated with all the latest developments online, on air. Let's continue the conversation. Barbara?
Well, thank you there, Eric. Matt Fleischman is a partner with the Rosensteel Fleischman law firm here in Charlotte, joining us this morning to really talk about what's going on with this and mistrial. I mean, I don't think any of us expected this, at least not this soon. So what exactly are we thinking here?
Well, I mean, what you've got is some showmanship by the state as well as the the state as well as the defense team. The mistrial is not really for the case at hand. That's really arguing for appeal. You want to preserve arguments. Already. I mean, that started before the actual trial started. You have what are called motions in limine to keep evidence out or get evidence in. And so everything that happens in a trial, there's sort of two phases. There's the actual trial part of it, which is where the jury makes a decision, and then there's the appellate part of it, where an appellate court or potentially the Supreme Court decides whether the judge did something right or wrong, and that's what's going on here.
Yeah, because it's safe to say that both sides knew the evidence that would be presented, correct?
Correct. So, but what you might have had earlier on, which there's no way for us to know at this point, is the defense might have objected to a number of these pictures, and what they're doing by raising these objections again is preserving that argument for appeal. So if the officer loses this trial, then the defense can appeal it, and they would argue that the judge made a legal mistake in allowing this evidence to be seen by the jury. And if you don't make the argument during the trial, you have lost the ability to raise that argument on appeal. Okay,
so they are thinking ahead, and I do understand that. But let's talk about how this may go from this point on, as far as what they may be arguing on both sides.
Well, so right now you've got the state putting on evidence, which is very tedious work, and you know, some of the jury members are sort of dozing off, which happens at a trial. I like to tell my clients that a trial is putting your hands in the lives of 12 people, half of whom could be asleep at any given time during the trial.
Which is amazing because this is such a high-profile case.
It is, but what you have to understand is that the state at this point is putting on just pieces of evidence, and while the jury is expecting the trial like they see on TV or in the movies, that's not what you're going to get. You're going to get this piece of evidence that builds on this piece of evidence that builds on that, and so on and so forth. And that's, to be frank, can be boring. It's up to the individual talents of the lawyer to present the evidence in a way that's somewhat entertaining to a jury nowadays, as well as getting that evidence in for them to make the decision later on.
Okay, so we're running out of time here, but I do just want to stress, so we've heard from the woman who was at the home when he knocked on the door that night. We've heard from Jonathan Farrell's fiance. What about the body camera video from that night?
It's coming up. It's up to the state to decide when they want to put it in. They have to get certain foundational elements in before they can present that evidence. You know, again, it's up to the individual attorney to decide when they want to put in evidence in front of the jury. Personally, I would have tried to put that in as soon as possible. That's what people are waiting for. That's what they want to see. Again, that was as a strategy decision by the state in this case.
All right. Well, we thank you so much for joining us. As
pleasure.
Always, appreciate your perspective. I'm sure we'll talk plenty more as things unfold, Matt.
Thank you.
All right, and don't forget that you can always catch this and keep updated with everything going on in the courtroom today. Just update our Fox 46 app. Remember, you can stay up to date with the latest developments just downloading this app. It's available on your iPhone or Android devices. Search for it in the App Store or on Google Play. Eric?